Okay. So you're a student at A&M?
Yeah, I'm a classics major at A&M, and then I joined the philosophy club about 2 years ago, and then now I became the president, but Koepsell's the advisor. So through
Oh,
him
nice.
and his occasionally he gives meetings and presentations about his own legal theories.
Okay.
And he gave one about intellectual property maybe 3 semesters ago, and he
Uh-huh.
mentioned a friend of his who was a patent attorney who was with him in being against it as a concept. And then through pure coincidence, I was reading, I got into it. I will admit I started with Liquid Zulu
Yeah.
of all people. And then through him, he mentioned you in Estoppel and also intellectual property video that he created. And then I looked you up, saw that you were a patent attorney, and then it clicked. Like I
I
woke up at like
gotcha.
2 a.m. and I was like, wait a minute.
Small world.
And then found out that not only were you guys friends, but you were Houston based. I'm also Houston based, so it's very funny.
Oh, really? Yeah, and David
Yeah.
and I, we actually went to New York together to do the Stossel show on IP about 5 years ago, 7 years ago.
Oh wow.
So
That's funny. Funny.
yeah, he's a great guy. Very smart dude.
Oh yeah, some of his the IP one I can keep up with kinda.
Yeah.
His Adolf Reinach theory of rights was challenging, but then when he started talking about legal ontology, I don't think anybody could follow.
Yeah, I'm not a philosopher, so but
Yeah.
I'm not aware of his Reinach theory of rights. I've written a good deal on Reinach and his some of his stuff. So I'd be curious to look into that. Yeah, Reinach, I actually published well, I'm familiar with his a priori theory of the civil law, which was in published in Aletheia in the 80s, I recall. I mean, originally published in the early 1900s. I think he was killed in World War One. But then he wrote one on the criminal law, but it was never published in English. And so I found a transcript, I mean, a translation of it by Barry Smith and one of his students, um, a woman who I forgot her name, but she's a European. And anyway, she gave me her translation, and I published it in my journal at the time, Libertarian Papers, which I don't publish anymore. But Britt Brogard, I want to say. Um,
Mhm.
anyway. Barry Smith's another smart philosopher, libertarian philosopher. Um, I don't think Koepsell's quite a libertarian, but he's pretty solid on IP stuff anyway. So
Yeah. I've talked to him about that. He is, I think, more of like a utilitarian in terms
yeah,
of his ethic, and then he
yeah,
grounds it with right ank, which is it's interesting. It's definitely unique.
yeah. I'll have to look into it. All right, what did you want to chat about? What you got?
Yes, I wanted to talk about argumentation ethics because I know I watched the YouTube video where you were talking to Murphy about each other's responses to papers concerning that topic, and you expressed how argumentation ethics is usually used to convince people who already were libertarians and to ground that into a more like I guess grounding. For me, it actually was what
Hmm.
got me into it as an
Okay.
ethic. Um because of I guess the philosophical interest. So that's what got me excited about it. And I wanted to write about critiques and responses to those critiques almost as if I'm steel manning the position the best I
Hmm.
could.
Hmm.
I'm doing so for the undergraduate journal at A&M for philosophy.
Hmm.
We're partnering with them this semester, and I wanted to submit my own publication for that. And
Okay.
talked to Kepsel, and then he's mentioned you, and I was like, whoa, this would be a great opportunity to get from the source
Yeah, and I
information.
think I sent you the main stuff I would look into on this. I think you've
Yes.
seen it by now. Hoppe's given a recent talk about 5 years ago, 7 years ago on this. That's the last time he really talked about it in detail.
Hmm.
And he actually did respond to some of his critics. But in the meantime, I responded to some of the critics, and a few others have too, like Brassow and Frank Van Dunn.
Yeah.
Um, yeah, and when I said it's mainly meant to explain why we believe things, yeah, I find the argument persuasive. It really blew my mind when I read it in law school. And look, I've known people who have come to libertarianism through reading my stuff on intellectual property. So you never know how people get to a certain idea.
Yeah.
I do think it's persuasive argument. Um, I think one thing I meant was a lot of people say you're not going to use that to persuade like a socialist,
Yeah.
as if that's a refutation of the soundness of the argument. It's like, well, just because it
Oh,
doesn't persuade someone doesn't mean it's not a sound argument. So persuasiveness is not the litmus test of whether an argument is sound. Um, but because it's sort of a transcendental type argument where what you're really doing is avoiding the is-ought gap by you're going from ought to ought. So it's a
yeah.
logical argument, and you're pointing out that there are certain basic oughts, which I call Grund norms, kind of following Kelsen. And I don't know if that terminology is idiosyncratic on my part or not, but it seemed like a useful term to me. Um, it's um, you're going from ought to ought because you're pointing out there are certain basic norms which are unavoidably presupposed in argumentation. Um, so you're going from ought to ought.
That's what
Now,
I found
yeah.
interesting about it at first, because I would admit that when he talked about Reinach Capsule, he gave a meeting about that. He was talking about his a priori
Hmm.
of contracts.
Yeah.
And that's when I was around the same time learning about the is-ought gap from Hume.
Hmm.
And I was thinking about it, how the is of a contract is created through the ought, and then it has certain obligations within it. So if you take it
Hmm.
upon yourself to enter into a contract, then there are legitimate objective obligations such as to fulfill it.
Well, that would get us into a whole different topic, which I've just written on. I just wrote
Oh,
a long paper on contract theory. I'll send you the link after, but
oh, great. Thank
I
you.
mean the example's fine. I think it's in reality that
It's
example's
probably a sloppy way to
it's not just
express it, but
sloppy. Well, you're using the existing sort of terminology. You're using the existing um, theory of contract that most lawyers and legal theorists use, which I think is somewhat wrong. Like I actually think contracts do not give rise to obligations at all. Um, but that's the Rothbardian title transfer theory, which and my sort of massaging of that. Um,
okay.
um, it gives rise to transfers of ownership. Now that could give rise to an obligation if you already accept um, that ownership rights are enforceable and that they have that they have that rights always have a corresponding obligation. Like if I have a right, then that imposes on you a duty not to invade the right or to respect the right. So rights and duties are reciprocal, and those are both normative concepts. Um, but again, the contract doesn't give rise to an obligation. What it gives rise to is a change of ownership. But ownership is a normative term too, because that's a legal normative term. So again, saying you have an obligation to respect property rights presupposes um, your obligation to respect rights and law in the first place. So you're already in
That's
the realm
another.
of shoulds or norms when you're talking about obligations. Um, Well, see, one thing most people don't point out, and I haven't written too much on this except in passing, and I think it's something someone needs to do, and maybe I will someday. Do you know much about Austrian economics?
I have been getting into that as extension, like human action just came in the mail
Yeah,
5 days ago.
yeah, or even just regular economics, just the concept of exchange, for example.
Yeah.
So the concept of exchange, I think maybe it's just English, but the way we use words in English, there's a potential ambiguity because economics in principle has got nothing to do with oughts or norms or shoulds or even
Yeah.
with law. It only has to do with a description of the consequences of action, which is a totally value-free category.
Hmm.
So in principle, economics could describe the way it could describe the actions of someone alone on his island, Crusoe economics, that's called. It would be a very simple economics, but it would still be economics proper. So you could say, you know, uh, you're choosing among ends to when you do something, you're choosing means to achieve those ends. The choice of ends implies value in preference. It implies opportunity cost. Um, the action implies profit and loss, subjective profit and loss, or psychic profit and loss. Um, all those things are implied in the category of action per se. Um, and concepts like investment and savings, those all apply. And when you have multiple people, you make you make the assumptions a little bit more rich to get an interesting analysis, but not with money. Let's just say a barter society. Even that can be described in purely descriptive terms. Like you can explain why people engage in a certain action. They do it to get the end they chose. Why they
Hmm.
engage in interaction with each other. They do it for the division of labor, specialization of labor, and to trade with each other. But that trade, when you describe it simpliciter like that, it only means economic trade. So why do I hand you this apple and why do you hand me your orange in a trade? Well, the economic explanation is you handed me your apple to get the orange and vice versa. Doesn't
Yeah.
necessarily mean that there's anything legal about it. Like there might not be ownership recognized. It's just why you do something. And then usually we have laws on top of that in society where there's ownership of the apple, not just possession. So like the first action could be described as transfer of possession. Why do you do that? I give you the apple because my belief is, my hope is that that will induce you to hand me your orange. It doesn't mean you own it or that I own it. It's the reason why I do something. So it's a description of why I do things. But when we assume that there's not only interaction and trade between people, but there's also laws and ownership, you go from possession to, which is factual and descriptive. You go from that to ownership, which is prescriptive and normative and legal. Um, and the problem is that when you describe an exchange, you could be talking about an economic exchange, or you could be talking about a legal exchange, and they're different, but the words
Mm.
used are the same. So people get confused by that because, for example, in intellectual property, you'll often have someone say, "Well," and I have a chapter in my book on this. On why selling doesn't imply ownership and vice versa, because the terms can be applied to different realms. One can be the descriptive realm of human action in a sense, but one can be the prescriptive realm of human action um, in a context where there are norms and oughts and shoulds and laws and ownership. So someone might say, well, Kinsella, you claim that intellectual property is not valid, which means that you don't own your ideas, but yet you think that you can sell your ideas because it's okay to have a contract where I sell my knowledge to you and you pay me money for it. So you must be buying something. And if you're buying something, I must be selling it. And for me to sell it, I must own it. So you see, but they're using these terms back and forth from the normative and the descriptive realm, and it leads to confusion. So that's why the contract thing matters. If you view a contract as only the transfer of ownership, then technically speaking, if I say I'm going to pay you $1, well, let's say I pay you $100 uh, for you to paint my house. In economic terms, we would describe that as an exchange or a trade because we're trying to explain the reasons why each person performs that action. So one person gives the money to induce you to perform an action. That's why I do it. The means I use is giving you the money. The end I have in mind is to get you to paint the house. And the reason you paint the house is to induce me to give you the money. So it's symmetrical. That's an exchange. It's a symmetrical exchange in economic terms. But in legal terms, there's only one title transfer. The title transfer is when I transfer the ownership of the money to you, but you didn't transfer any money to me. All you did was perform an action.
Yeah.
So the mistake there is in making the analogy because the language is the same. Like I say, I buy that from you. If that has a legal meaning, it means that you gave me ownership of your money and I gave you ownership of the thing you bought. If it's a thing that has ownership, like if you buy
Yeah.
a car from me, I have ownership of the car and you have ownership of your money. That's a bilateral or a mutual transfer of ownership. But if you buy a service from me, there's only one title transfer, but economically they're both exchanges because in both cases you could explain each person's action by what they hope to achieve in economic terms. Anyway,
Mhm.
but go ahead. I'll let you. I derailed you, but go ahead. I'll let you get
Oh,
back
no,
to your
not at all.
example.
That's interesting. It reminds me the example you gave of, oh, but you can sell your ideas, so you can own ideas. That sounds
Correct.
like a similar, but the opposite argument is the one about if you own your body, then you could sell your body. Makes
Yeah,
sense.
that's another one. I talk of that one in another chapter in the book. It's about inalienability. And again, so there's a slight difference though. So in the case of sale of labor, I'm pointing out that there are two senses of the word sale,
Yeah.
and the word possession is a descriptive word, and the word ownership is a juristic or a legal word. So you have to be clear on what you're talking about. So if you untangle that, you can see that in the purchase of a service, you're only there's only one title transfer. Okay. But in the case of the body, the slight difference so the thing is when I perform a service for you, like I paint your fence, you could say I sold you my labor, but it's just a metaphorical description of what I'm
Yeah.
doing. If you look at it closely, no one really can seriously maintain that I own my labor, because it's not like after I perform the service, I had the labor in some bucket and now you have it. It's just a metaphorical description. However, in the case of human bodies, there is a meaningful sense in which you do own your body. Okay, so if I own a car, I can sell it to you because I own it. That's true. So you would think that the ability to sell is implied by the capacity, or by the nature of ownership, because that is possible when you own a car. And then you would think that, okay, then likewise, if you own your body, which is implied by the idea of non-aggression, if non-aggression
Hmm.
means that no one has the right to use my body without my permission, which is another way of saying I own my body. So clearly we have ownership of our bodies. And if you assume that, well, ownership means that you can sell it, then a contract to sell your body would be enforceable as well, which is what Walter Block argues. And my argument is that the mistake there is that in assuming that the ability to, or the right to own something, the right to control it, the right to exclude people from it, necessarily implies the right to get rid of that right. It doesn't necessarily. And my argument is that because there are different modes or ways that we come to own or justify our ownership of our bodies and other things in the world, there are different ways that you can get rid of that right. So the reason you can sell an object that you own is not because you own it, but it's because of the way you came to own it. And the way you came to own it was you found it in the world when it was unowned, and you acquired it. And if you can acquire something that was unowned, then you can unacquire it by just getting rid of the intent to own it. For example, again, if you take seriously the distinction between ownership and possession, then owning something is different than possessing it. Like Crusoe possesses a stick, but he doesn't own the stick because there's no one else that he has a right against. But in the world where there's laws and norms, you can possess a stick or you can own it, and they're not the same thing. For example, if I own a stick and I possess it, those are two different things. But if I loan it to you, I still maintain
Yeah.
ownership of the stick. So possession and ownership are different statuses. Um, so by the same token, if I come to possess an unowned stick in the woods, I don't necessarily own it if I don't have the intent to own it. I might just intend to use it briefly and then throw it away. So I never owned it. Um, so by the same token, if I own something that I do possess, I can separate ownership and possession. Like I can hand the stick to you and let you use it. So you possess it, but I own it. And then I can abandon it. So now I no longer
Yeah.
own it. And now you own it because you're in possession of it. And if you intend to own it, now you re-homestead it, so to speak. So that's sort of the contractual mechanism. That's the reason why ownership, as applied to acquired things, implies that one thing you can do with it is to give it to someone else.
Forgo the
But
ownership.
in the case of your body, you never acquire your body, because acquiring an unknown thing presupposes that you already have a body. Because to acquire an unknown thing requires an action, and that requires a human being with a body. Um, so it would be nonsensical to talk about acquiring your body unless you use some mystical religious argument, like, there's a soul and God sends it down, and but that's just not a rational argument. So the reason we own our bodies is simply because, uh, not because you're the first user of an unknown thing, but because you have an intimate, direct connection to your body, which I argue in my book. And that's the reason. But that's an ownership, which means that no one can use your body without your permission. But it doesn't mean that they gain that right to use it later on when you object, just because previously you uttered the words, "You can use my body in the future if I, uh, without my permission," or with you have my permission now to use my body in the future. It doesn't mean you can't change your mind. So to me, that's the distinction between types of ownership, and that's why the ability to sell something or to transfer it is not a part of ownership. It's a part of, it's like saying, if I own a house, it includes within it the right to dance naked. Well, it doesn't really include within it the right to dance naked. It's just that the right to a house gives you the right to exclude others. And
Mhm.
practically speaking, that gives me the ability to be naked inside that house, right? If I own my body, it gives me the right to tell you no to use my body without my permission. And that gives me the ability to prevent you from using my body without my permission. But obviously, the relevant permission for something that you own is the most recently stated or communicated permission, not the previous one. So, for example, if a woman tells you, in an hour, I'll let you have sex with me, and then you do it in an hour, we presume that it was consensual because that was the last thing she said. But if she says no when the time comes, and you go ahead anyway, that's called rape.
Yeah.
And the defense wouldn't be, his defense couldn't be, well, she said yes an hour ago. I mean, it's the most recent communication that matters, because that's what ownership is. It's the right to say, to communicate your choice, whether to give permission or to deny it. In any case, go ahead.
Yeah, it sounds similar to like a will. It's always the most recent version that matters. And then that important distinction between direct and indirect control, I know Hoppe makes clear in the lecture that you sent me from 5 years ago. And I think that kind of helps me understand that how you can't sell your body, it's inalienable. You can't forego that ownership claim as opposed to a stick, which you can because you acquire it.
Right. Now, just to be clear, this is my argument, and I don't know if it's widely accepted. It's sort of a
Mm,
legalistic and very careful argument. I'm sure Hoppe would agree with me on this. Um, Lots of other libertarians seem to be confused on a lot of this. However, I will say that almost all libertarians I'm aware of, well, I don't know what the percentage is, but if I had to guess, the percentage of libertarians that agree that you can sell your body into slavery is very small. It's Walter Block, um, uh, Robert Nozick kind of implies it. I doubt he would. He's
really?
dead now, but yeah, I can find that passage. It's in Anarchy State and Utopia. It's because he had a
Yeah,
simplistic understanding of a contract. Again, if you just think
sure.
contract is something that you can, by mouthing words, obligate yourself to do, then what's the difference between your body and other things?
Yeah,
But again, if you don't think of contracts as obligations, that helps to solve the problem. And if you see the distinction between different types of ownership, that helps. But Walt Nozick didn't see that. He was more simplistic. And then I think also Gerard Casey, who is a recent guy in his book, he has a comment. He doesn't really go to detail, but he has something. So I think Casey, Nozick, and Block, almost everyone else basically seems to intuit that there's inalienable rights. They don't really have a good argument for it. The best argument is mine, really, and then it's implied in Rothbard's arguments against his arguments against voluntary slavery. He gets it a little bit confused because on the one hand, he wants to view contracts, according even to his new theory, he wants to say that if you don't pay off a debt later, it's implicit theft, which is not true. He says that because he has a revolutionary, brilliant contract theory, but even he doesn't understand what it implies. Like, so he's thinking that if you don't pay off a debt in the future, you're a thief. And so, in theory,
Yeah,
debtor's prison would be
it-
justified, but debtor's prison means you could bind yourself by your promise because it could be backed up by force, which goes against the idea of inalienability. So he's a little bit confused on that. I've tried to sort it out in that article I'll send you on contract
and
theory.
I would imagine to be a thief in that situation, you would have to be owning or possessing something which you don't own, but then there's
Correct.
no thing.
There's nothing to
The money's not there.
yeah. So that's the first thing. So if you ask Walter Block or Rothbard, okay, what thing did you steal? Then the
Mm,
first answer is, well, you're stealing the money that you owe someone. I'm like, well, if you don't own anything, there's nothing to steal. And so then Walter would
yeah.
say, which I've had a debate with him, he'll say, okay, it was so let's say a loan for $1,000 on day one to be repaid, 1,100 to be repaid in a year. If the debtor doesn't own the 1,100 when he's, by the way, if he does have the 1,100, then ownership does transfer to the
Yes.
creditor. And if you refuse to turn it over, then it would be theft. But if he doesn't have any money, then there's no future title to of anything to steal. So then Walter would say, okay, well then it was the original $1,000. I said, well, so on day 1 year from now, you're making the act a year ago retroactively theft, even though it was consented. It doesn't make any sense. You can't retroactively steal something. And not only that, the $1,100 was given so that the borrower could spend it. He has to be able to. He has to own it completely. This is the
Yeah.
thing. Walter Block would say, "Well, the transfer of the $1,000 is conditional on you being paid back later." But as Hoppe points out, you property rights have to be able to answer the question right now: who owns what? You can't have to wait for something in the future. And this is clear if you don't make it money with interest because it seems like you're repaying the loan. If you just make it two different things, like I give you a hammer now, and in 1 year you transfer to me I don't know a shovel. So they're just two different things. So obviously the ownership of the hammer is transferred outright, and the ownership, and that's a future that's a present title transfer. It's done, gone now, and it's done. And it's reciprocal, and it's related to a second separate title transfer, which is a future title transfer of the future shovel. But that's a future thing which doesn't exist yet. That's why
Yeah.
all future transfers are always conditional. They're conditioned upon the thing existing at the future time and being owned by the person who's supposed to transfer it. Those two things have to take place for there to be sort of an obligation to transfer.
I think Liquid Zulu goes over that in his contract chapter,
I
that
think he
exact
does. I think he
example.
does touch on it. I think you're right. Yeah.
Um,
Now,
I have a pretty,
did you want to get the
yeah,
actual criticisms of argumentation ethics or the responses to it?
yeah. So I went through Murphy and Callahan's critique, and then I went through your response to that critique. There were a couple questions that I had in general about argumentation ethics, and then I had a couple that stemmed from reading both of those.
Okay.
My first one was from Hoppe himself. I guess because, my club, I would admit, where there are a lot of, and I myself came from this background, a lot of rational and relative skeptics and ethical skeptics. And
Okay.
so that's who I would be, that's the sort of crowd I would be dealing with for the most part when defending the paper. And so my first question was, why does scarcity mean we require property right norms?
Why does scarcity mean require property? Well, Yeah, and as you might notice in my writings, I scarcity is fine. It's just that's another word you have to disambiguate because it has different
Yeah,
connotations. So I tend to use like rivalrous or even conflictable to refer to the conflictable nature of things, things that there could be conflict over,
yeah,
which are scarce means of action. It's just that the word scarcity for some people, in a technical economic sense,
yeah,
as we use it, it implies rivalrousness. Really, it means
yeah,
yeah, but in common language, it means lack of abundance. So
yeah.
yeah,
I will go into
yeah,
that because
you
many
just have
times
to
I hear people
distinguish.
talk
Yeah,
about how, oh, there's no longer a scarcity
yeah,
of things
yeah,
in the world, and it's
yeah.
like
But so
that.
I would say if there's 1,000 bananas and you and I are sitting there and I have one of them in my hand, then if there's a dispute over who owns that particular banana, like you take
Then
it
there's
from
still
me, then that particular banana, we would call it a scarce good. It's got nothing to do with how abundant it is. Although in the limit, in a world that's an unrealistic world, the world of the Garden of
part in
Eden,
the Eden example. Yeah,
and that kind of thing, um, there would be no property rights because there would be no conflict because and there would be no theft because if someone took my banana, I would just conjure up another one. I wouldn't lose
yeah.
anything. And on the other hand, they would never take my banana because they could conjure one up too. So the whole concept disappears. Um, so I think Hoppe goes into this. So there's two aspects to it. I guess one is the nature of human action, which is always the employment of these scarce means to achieve an end. And the nature of these means is that they're not super abundant. That means there can be conflict over them, which means basically, in practical terms, only one person can use them at a time. So that's really
Hmm.
what's going on here. And then the second issue is whenever this question comes up, it's always in the context of an argumentation between two people who are discussing norms. They are discussing this possible conflict over this use of this resource. That's what the context always is. Um, in other words, whenever you say who owns this or what should the law be, you have to decide that in the course of an argument or a discussion. And in such a context, both parties are necessarily presupposing certain things. There's normative presuppositions of an argument. Um, there's practical and normative presuppositions. The practical ones are that you had to be alive to get here. You had to use scarce resources to get here. You can't outright condemn the variability of people to use resources or to use them in the first place. Because if no one could use something in the first place, we would all still be dead because no one would have been able to use something in the first place.
Yeah,
So if you're looking for norms, which is what you're always doing in these discussions, you're already presupposed that you're already taking for granted that there's conflict that's possible. In other words, that's the nature of the world that things are scarce. So every discussion about what norms should be in place is always a discussion that takes into account the possibility of conflict. I don't see how anyone can deny that. Even a socialist can't deny that the things that we're discussing and saying who should own them are things that by their nature can only have one user at a time. And if we are to avoid conflict, which again is the purpose of a norm, coming up with a rule that people can follow to avoid conflict. If people don't want to avoid conflict, they wouldn't engage in discussion. They would just use whoever has the most
yeah,
might would just take it. So then the only question becomes, well, then what's the norm that would reduce the conflict in the use of these resources? And number one, that can only be the norm that uh, is that's compatible with any other norms that you're presupposing as part of discourse. And one of those is peace, and the other one is recognition of each person's self-ownership of their body. The reason that self-ownership is presupposed is because when you're having a genuine, rational discussion about what norms we should agree or to adopt mutually among each other, um, you're necessarily going by the force of argument alone. In other words, there's no coercion there. In other words, I'm not trying to persuade you to adopt my claims or my argument uh, based upon the threat that I will physically harm you if you
yeah,
don't. Because if you do, that's just coercion and that's not a genuine argument. So there has to be an implicit recognition that as Hoppe talks, a willingness to walk away. a willingness to agree to disagree. If there's not that, then it's not a real argument. And no proposition about who owns what, what's right and wrong, as Hoppe argues, could ever be solved except an argument. And that's undeniably true because no one can deny that's true because
without
if
arguing.
they have to be in an argument to even deny it. So I think that's all true. And so it's all that's left for the socialist. By socialist, I mean anyone who doesn't agree with libertarian political norms. Anyone who's arguing against libertarian political norms. Someone who's in favor of slavery, someone who's in favor of redistribution, egalitarianism, rule by a king, whatever they want to argue, they're arguing for some political norms, and they have to take into account, they have to take for granted that the right to agree to disagree, and that everyone has to have the right in the beginning to homestead unowned resources to be able to survive. And then this is where Koppe's prior-later distinction comes into it. So he points out that the prior-later distinction is an inherent and necessary part of what property rights are. And the reason is because you can't base the property right principle on mere verbal decree or arbitrary assertions. Otherwise, again, it's not a genuine argument. To argue means to give reasons grounded in the nature of things, which means that I can't simply say, well, the reason I own that football is because I'm me and you're you. That's, again, not giving a reason. It's just resorting back to violence
Particularly.
and force. Okay? So you have to give a reason. And I can't say I'm your owner and you're my slave, and that's justified because you're black and I'm white. That is a distinction, but you have to show that it's a relevant distinction. Or I'm a man and you're a woman. Or I'm 6'3" and you're 6'1". Those are distinctions, but they have to be relevant distinctions. And unless you can give a reason why that's a relevant distinction, it's just arbitrary, and it doesn't count as a reason. It has to be grounded in the nature of things. So all we really know is that when we both come into this argument, we're both assuming each other has body rights because we're willing to respect each other's body for the purpose of the argument. And we both assume that everyone, at least prima facie, has the right to use unknown resources in the world that were previously unowned. Otherwise, we wouldn't be here. Okay, so once you accept that, and then you accept the norm also that the current owner of something is now the owner, and they can't be dislodged from that ownership unless they transfer it consensually by contract. If you don't believe that, then again, we're not talking about ownership, we're talking about possession.
Yeah.
Right? Because otherwise it's like, well, then I don't care who owns it. I'm just going to take it, and now I take it. Again, you're back to just bare physical force, which
Might
is not
makes right.
argument. Okay, so that means the current ownership has to matter, but what that implies is that the current owner has a better claim than someone who comes after by virtue of what ownership is. But if you go back in time, sort of like the regression theorem for money of Mises, that implies that the very first owner of an unknown thing had ownership of it until they sold it voluntarily to someone else, right? So that's why the current recognition of mutual body ownership in an argument implies number one, the prior later distinction, which means that it implies that we're searching for ownership rules for the current things in dispute. And that search for ownership rules implies that the current owner has a better claim than a latecomer. Okay, because that's what it means to recognize. Once we come up with the answer to our argument, like who owns the football, is it me or is it you? You're the owner. That means you own it
Yeah.
until you give it to someone else. But that necessarily implies the prior later distinction, and also because you cannot deny the you can't deny the justice of someone being able to acquire an unknown thing in the first place, because otherwise you wouldn't be alive. And furthermore, if you take an unknown thing in the wilderness, there's no one that can complain that you took it from them, right? Because
Yeah.
otherwise they would be an owner already, and that's against the assumption. Okay, so again, those 3 or 4 assumptions, which are virtually undeniable, goes back to mean that the first owner has to be the owner. So that's why the only norms that can be justified for ownership of external resources or property rights. That's what they are. That's what you're looking for when you have a debate about who should be able to control this thing. And that's why the only ones that can satisfy that are those that are rooted in the ability to acquire something first, which we call original appropriation, and the maintaining of that ownership unless you consensually transfer it, which is why contract enters into the picture. So the three core rights of libertarianism are they come from the context of an argumentation, which is the only way you could ever justify these things. And those are self-ownership, original appropriation, and transfer by contract. And then there's a third one, which I view as a subtype of contract, which is if you transfer it because you have to pay someone restitution or compensation if you harm them.
Mhm.
But again, you could look at that as a type of contractual title transfer. Like if I punch you by that action of aggressing against your body, I've consented at that moment to you taking some of my resources to pay you back for the damage I've done. But so those 3 or 4 principles are basically the core of all political philosophy and all libertarianism, and the way that we look at those 3 things is what distinguishes libertarianism from every other political philosophy. Most other political philosophies adopt these views, those principles, to one extent or the other. It's just that they make a lot of exceptions. So most political philosophies would say that they agree to body ownership. They oppose slavery in most cases, but they don't do it
Yeah.
completely. Like, yeah, you own yourself unless you don't pay taxes, or unless you refuse to fight in our wars,
Yeah,
or
well,
unless you smoke marijuana, and then we can put you in jail and treat you like our slave. But unless there's an exception, but the point is they're exceptional. The general rule is that everyone owns themselves, and the general rule is that you own your body until you part with it consensually, unless the government takes it from you by force for taxes. So they make exceptions. So the libertarianism rule is simply the one that has no exceptions, and that it's more consistent than the others.
I had a question about when you were talking about how you can't make a distinction between 6'1" versus 6'3" and things like
Yeah.
that, or black versus white. It has to have a distinction that matters. You mentioned with the Murphy YouTube video how a distinction that would matter is if somebody was committing a crime, then you could legitimately imprison them. Are there would those distinctions that matter revolve solely around them already having committed a crime? Or are there other situations where that could happen?
Um,
I'm gonna look at my notes and see if I could
no,
find
I
it.
think it is. I'm sure. And I think this is implicit in Hoppe. He doesn't always go into those distinctions, and I've talked to him, and I'm pretty sure he would agree. When I tried to defend him in that argument and in others, I tried to. So one of Murphy and Callahan's things is, well, you could argue with your slave, that kind of thing,
Yeah,
as if that's a counter argument. And I understand why they might have made. Well, I think it's a mistaken argument, but I understand why they might have made that argument because Hoppe doesn't explicitly make the distinct. He doesn't make the exception about if you own a slave that's committed a crime against you. I think that's implicit in his theory. So the way I would look at it, so yeah, I think the answer is yes, and the reason is because for the same reason that your body rights are inalienable. And by inalienable, I don't mean they're I don't mean they're really inalienable. What I mean is that they're not alienable by contract, but they're not alienable, which is another way of saying the only way someone can have a right to your body um, is number one, if you grant them permission by communicating it, okay. But if the only way they can have a right to use your body, even when you say no, um, uh, is if they committed an act of aggression. But not if they merely said you can use my body, because you have the right to change your mind. And the reason is because telling someone I sell you my body is not an act of aggression. So saying words to someone doesn't invade the borders of their property and doesn't give them any right to commit aggression against you. Now, Walter Block and others will say, well, but then why can you sell your car to someone?
Yeah.
So again, they're thinking that it's magical words that have this effect of changing your ontological status, but they're forgetting the reason for all this, and the reason that saying you own my car now transfers ownership is because the way you came to own it was the combination of your intent and your possession. It was a combination of those things. It was a previously unowned thing which had the status of being unowned, and now it has the status of being owned by you because of the union of your intent and your possession. But if you get rid of one of those two things, if you get rid of the intent part, you're just possessing it. You don't own it anymore. And because you came to own it or acquire it by an act of intent, you can get rid of that by intending to abandon it, and you can do that by your communication to tell people what the status is. Just like if I own something, if I pick up a stick, I can tell people I don't own this, I'm just using it temporarily. So your communication of your intent can tell them whether you're an owner or just a possessor. By the same token, if I own something that I already own, I own it until I change that status. And one way to do it would be to die. If I die, I don't own it anymore, right? Another way to do it would be to abandon it forever in the woods, and I just no one. And then let's say there's no trace left anymore of my ownership to it. Someone else could treat that as unowned and re-homestead it. And another way would be to like physically hand it to them and say, you possess this car, and now I abandon my claim to it, so now they become the owner. It's not
Um,
magical. It's
s-
just I've relinquished my intent to own it, so I don't own it anymore. So that's why your your verbal or your written communication that you own this works. It works because I've gotten rid of my intent to own. But your body is not owned because of your intent to own. It's owned because you have a better connection to it. So merely saying I don't own my body anymore doesn't change that fact. You still have the will. That's what Rothbard talks about in his argument. Like you still have the will over your body. Now, here's where people they say, well, then if that's true, why can you argue with your slave? And why wouldn't that mean you could never justify imprisoning someone who's actually an aggressor? And the answer is because in that case, so if I'm a Roman guy arguing with my slave, Hoppe would say you actually cannot argumentatively justify keeping him as your slave. You're engaged in a performative contradiction because you're treating him as if he's a self-owner, and yet after the argument's over, you go ahead and you use force against
yeah.
him, even though you've already conceded you shouldn't do that. So you're caught in a contradiction, which is why no ethic other than libertarianism can be justified. But if a guy's on my farm and he just murdered one of my children and he's a rampaging threat and a menace and he's done damage to me, and I subdue him using self-defense, and I put him in a cage waiting for, I don't know, waiting for the local private defense agency to come to cart him off to, I don't know, eject him to Siberia or to kill him or whatever they're going to do with him. I'm treating him for that finite duration of time as my slave because I am treating him as a means to my ends. I'm disregarding his verbal assertion that of no when he denies me the ability to control him. So if we have a discussion about it, I could justify treating him differently. He could say, "Oh, you don't have the right to treat me like your slave because we're both equal." As far as we know, we're both equal because we both have the capacity to reason. We both need things to survive. Um, and you're recognizing my right to use my vocal cords right now. And the response could be, yeah, but I'm your owner because not because I'm me and you're you, but because you committed an act of aggression against me. So and that's not arbitrary or irrelevant. If I said I'm white and you're black, there's no,
And it is.
I can't give a reason for why that distinction is relevant because for whatever reason I have for rights, it's not because of my skin color. It's my rationality, it's my will, it's something that we share. It's a capacity we both share, but it's not my skin color. Now, I could say that, well, God told me I'm special, I'm the chosen people, or something like that, and you're just an inferior person. So that's why. But now I'm resorting to something mystical and something supernatural and something irrational which we can say is also not permitted in a rational discourse between people. Uh, that's not in the nature of things. That's some mystical text. So I would say that doesn't count either. And also, it wouldn't count for me to say, well, it's because you're black and I hate black people. It's like, okay, but you haven't related it to the reason why we're assuming we both have rights, which is something to do with our mental capacity, right? But now our rights do have to do with mutually respecting each other's rights and living in the world together. And if someone's committed an act of aggression, they have put themselves outside of that. They've distinguished themselves.
Yeah.
Now they're an aggressor and they can be treated differently because they did not respect my rights. And because they didn't respect this is where my estoppel theory comes into it. Because they didn't
Mhm.
respect my rights, I don't have to respect their rights. Sort of like a symmetry is there. So that's why I think that uh, it's not a debunking of Hoppe's argument to show that there are cases where you could have an argument with a slave where you could justify enslaving him. Now, another one they give is I think Murphy's religious, and I don't remember. He goes into this thing. Well, if God owns us, to me,
Yeah.
this sort of like Mises' kind of offhanded arguments about. He says, well, human action is an undeniable praxeological truth because you can't deny that humans act, and when they act to in a world of uncertainty to achieve some end because they're dissatisfied right now with the current way that things are heading, and they want to change that. So if we imagine a God, God is conceived as being perfect and all good and all omniscient and all powerful, omnipotent. And therefore, it's inconceivable God would ever act because to act means that he's dissatisfied with something, but that would imply he's not perfect. So I mean, I actually think that's an argument by Mises why God can't exist because he's an impossible thing. It just, but
Yeah.
basically he's like, okay, well, if God exists, then we're going to have to separate him from this category of action. It only applies to humans on the earth. What he really means is it's a nonsensical concept. So if Murphy wants to say, well, there's a God up there and he's really our slave owner, okay. But even if there's a God who created the universe and because he created it and because he's omnipotent and he's all good, and he has some kind of super moral right, some super right to just treat us like his ends. Let's say that's true. That still doesn't mean that we have that right with respect to each other, because on this earth and in this moral plane, even in God's eyes, he put us down here as equals because he gave us all equal ability to use the resources on the earth that he gave us. So it still wouldn't justify socialism. It might
You're still
justify
there.
God being a dictator, but that's not really our problem here. And if it was our problem, we would have bigger problems because if God wants to be our dictator, there's nothing we can do to change his mind or stop him because he's omnipotent. So it's just a silly, uh, it's a distraction from the argument, I think.
The distinction that you were talking about, the black and white one, it's similar to the same paper he mentioned, the Aristotle and the Barbarians one.
Yeah. Now you
Yeah.
could use it for children's a more interesting case because
That's my next
you
question.
well you could say that so you could say then why does a father of let's say a 3-year old have the right to do things to him that he wouldn't do to a neighbor? Um, and again, the answer is because you could point to a difference. You could say, well, the child is obviously he has rights or he's growing into a point where he has rights, but because of the way humans develop, this is again grounded in the nature of things. Because of the way humans develop and our social nature, and because of my special connection to him. I'm the father of him. I have a better connection to him than a stranger because of all these things, and because of his incapacity. He just doesn't have the maturity or the rational faculty to make decisions yet. It's obvious that you could argue that there's a continuum when he's born and even before he's born to when he develops a certain level of maturity and then has full ownership. But between that point, he has less than full ownership, which means that someone else has the right to make decisions on his behalf and in his interest, which is presumably the parents. They can use that right by abusing it, and then maybe some other adult would have the rights, the supervisory rights, the guardianship rights. Um,
That's why I really liked Walter Block's decrypted will analogy. I thought that was
which
a great
one?
way to the
Which one?
decrypted will analogy
Decrypted
from
will.
from Walter Block, where the rights of a child, much like a decrypted will, as they age, you slowly decrypt what rights they're able to express of
I
themselves.
never heard that, but that makes a sort of sense to me. In other words, it's a
That
continuum
was part
where
of the contract and the rights of children chapter of Liquid Zulu's course.
decrypted will.
Yeah, like or encrypted will, where you're slowly decrypting it, and then as the child age, it's much like that, where
Okay, yeah.
certain parts of it become available as
Yeah.
to how they're able to express and consent to
Yeah.
certain.
And I would, yeah, so I would, the way I would word that is there's when the natural parent of a child who has not abused the child and who is fulfilling their sort of natural obligations to take care of the child, uh, when that's the case, then we presume that the child would consent to whatever the parent consents on their behalf. Um, and that presumption can be broken in obvious cases of abuse or when the parent is not acting in the child's behalf, but is acting on their behalf. Like if you sell the child into slavery or something like that. In most cases, I would say. Um, um, yeah, so I would say that's a gradual thing. Although I would say technically speaking, the age of consent would be a lot lower than the current legal system's laws regulate, or at least it would be flexible enough to let a very young child, if push came to shove, if things got so bad for that child that he wanted to, and that's what Rothbard says, when the child is old enough to run away. Now,
Yeah,
that's a little bit that's a little bit too glib.
yeah.
I mean, 2 years old they can run away, but a toddler doesn't really have any. But I think a 5 or 7 or 10-year-old can basically commit enough of a. They can express their desire to be manumitted sufficient to, at a certain age, even in today's system, you can go to a court and you can ask the judge to free you of your parents. You can
Yeah,
manumit yourself before you're 18. And I think something like that makes sense. But sure, I would agree with that decrypting the encrypted will metaphor.
that leads me to my next question. Because children are growing into their ability to engage in consent for certain things over and appropriate resources and trade with them, what would the argument for the rights of, I know Murphy and Callahan mentioned this, like people with mental retardation.
Yeah. And I think that's an argument that's more of a that's not really necessarily an argumentation ethics argument anymore.
Oh,
That's more of a borderline or an edge case issue or a continuum issue, as Walter Block calls it. Um, I mean, the essence of rights, according to Hoppe's rights theory, is bound up with reason, the capacity to reason. Okay, we can say that for sure. So there's a clear case. The clear case is a functioning adult human. Um, does it apply to a 1 day old fertilized zygote inside the mother's womb? Opinions vary. My view is because it's bound up with rationality, not with personhood, which is just a tautological term. It's not with being a human, which by the way is Walter's argument, which I think is Walter's argument for abortion, or for choice, or whatever he calls it, evictionism, is that all humans have rights from conception because they're humans, but they're parasites on the mother, so they can be aborted. Um, I'm sorry, they're trespassers. I mean, I think both
yeah,
steps of the argument are wrong. You don't have rights from conception because you don't have a rational faculty yet, and you're not a trespasser because you were invited. So like both sides of this argument are wrong, in my view. I think the best view is that because rights are bound up with the rational faculty, it's clear that there's a time period between, let's say, late term of a pregnancy and somewhere in early childhood when when after that point children clearly have rights. Between in that gray area, you could have arguments about it. And I think what happens is in a rich and generous and benevolent society, people tend to err on the side of rights for the child. So because there's no clear answer and we can't just say what did God say, then out of respect for human life, we would say, well, um, a 7-year-old has rights. We're going to treat the baby like he has rights too, and even late-term abortion, we're gonna frown on. Doesn't mean you would treat late-term abortion as murder for other reasons, which I gave in my talk on abortion last year at PFS. I think you could argue that it's murder to to kill a healthy late-term fetus, but that the jurisdiction over that should be still with the mother. So it's up to her
Mm.
to decide to treat it like murder. Whereas we on the outside might treat it like murder. I think the outside legal system of the community should not get involved until the baby's born. But after the baby's born, it would be reasonable for a society to extend the right. Lauren Lemansky has a section in his book on persons' rights in the moral community. He's a philosopher and libertarian. He's got a section in there on what he calls piggybacking, how like the rights of what he calls defective humans, which I guess he means like retarded people and people in comas, people like that. Whether we attribute rights to them, the very infirm, the elderly, and I guess fetuses, he kind of treats them as edge cases, not really exactly having rights, but we attribute the rights of healthy adult people to them out of respect for their kind of affinity to us. And again, piggybacking, so like I'm walking, and if like a little child is with me,
Yeah.
I put them on my back to help them get across the stream. So they kind of get the attributes of my, and I think it's not a very rigorous argument. It's kind of metaphorical, but I think that's the best we can do to help sort this out. So I think the short answer is in their sense in the arguments of like Ayn Rand, I think she would say that,
Yeah.
in a sense, someone who's severely retarded or in a coma, they're essentially dependent upon the healthy people in the world helping them out. They're utterly dependent, just like a newborn baby is dependent upon its parents. Otherwise, it will die. And
Yeah.
because of this dependency, in a sense, they have to depend upon the voluntary help of the people. So the most important thing is to make sure you have a working capitalist society where everyone that's a functioning adult has their rights respected so that they have the ability to care for the people that need the help. And then we, as a practical matter, you always have to count on these people's generosity and benevolence to help out the people that need it. Whether you can say that, a severely retarded person has full rights, I think it's a hard argument to make. I think it's more of a moral argument at that point. Just for the same reason we wouldn't say that, a horse has rights. They just don't have the
Yeah.
rational faculty to have it. But we can still oppose needless cruelty of animals based upon moral considerations, but we keep them distinct. Not to equate retarded humans with animals, but there is a sense in which they all have a certain impairment of their faculty compared to the faculty of a functional adult human. Um, so I would say that at most you can argue by analogy and from moral principles to and hope for the benevolence of everyone to treat those edge cases, to extend as much of our status to them as we can, as much as we can afford to. And by the way, when you have these kind of difficult cases, people always expect the libertarian to have an answer for everything.
Yeah.
And it's not always possible. And a lot of Randians and a lot of anarchists and a lot of non-libertarians, they're bothered by that. But I always view these things comparatively. Like, um, for example, you could point out these are sometimes called lifeboat scenarios. You could have a situation where you have 3 people on a lifeboat and there's only enough food for 2 of them. How's libertarianism going to solve that problem? It's like, well, how is socialism going to solve the problem? How
Why
is
would anybody
nothing's going to, I
solve
mean,
that problem?
sometimes there's tragedy and sometimes there's situations where there's no good solution. And that's not because we have libertarianism. That's because the world is not always perfect
Yeah.
and justice and peace and harmony is not always possible. But in a case where we have that, we hope to make it better by adopting property rules that allow us to minimize violence and conflict. So again, I always point out, well, how's your property rights system gonna solve? Is it gonna magically make enough food appear for all three people on the boat to live? It's not gonna happen.
Some would say that scarcity will eventually stop being a concern. I've heard that.
Well, and I'm not too again, this is like the it's like this is why this like the scarcity versus abundance concept.
Yeah,
I could conceive of us reaching what we might call now a post scarcity future. What's it called? Post scarcity? Is that what it's called?
I think so, yeah.
But even that wouldn't really be a world of post scarcity. It might be a world of such superabundance that property rights don't matter as much anymore. Um, and if that's the case, but again, it's like the bananas thing. It's like if there's a billion bananas around,
I could still want that one.
I might want it, but if they're all the same, I mean, if they're all the same, they're homogeneous units of a good,
Hmm.
then there would be no theft. There would be no need for theft, and there would be no concept of theft because no one would care and no one would want to do it in the first place. So in a post scarcity world, everyone's physical needs are met. I just think that that is a little bit science fictiony because even in a in a post scarcity world, the best we're going to have is a world where there is no poverty left, like there's machines and plentiful energy and food where no one starves, no one is missing out on any material goods that they want. You're still going to have people have an attachment to their physical bodies and things they
Yeah.
like, and there's still going to be the possibility of murder and rape because people will still have free will. And so there would still be the need for laws and property rights to prohibit those things. So I don't think that this post scarcity world means that property rights go away. It could mean that money goes away because we have so much that we don't need money to coordinate our actions anymore. Because the whole purpose of money is to allocate scarcity in the sense in the non-abundant sense. If you don't care, if everything's provided for, then you
Yeah.
wouldn't care about economic efficiency so much anymore. So I could see a world where prices go away, although it's hard to imagine now. You need prices, as Mises pointed out, you need prices as long as you need to compare heterogeneous factors of production. You can't compare alternative ends if you're trying to make a monetary profit without money prices. But if you don't care about
You see,
monetary profit anymore, then I guess you wouldn't need money prices, and so money might disappear, like in the Star Trek world. But even in the Star Trek world,
yeah.
there's still crime and still property rights in people's bodies.
Yeah, because even in Hoppe's example, the Garden of Eden, he still explains how your standing room in your own
You need to
body.
stand in right. So you can't
Yeah.
if you take the hypothetical construct of the land of Eden or the Garden of Eden or the land of cocaine, he calls it. If you take that to an extreme, then it's just a fictional thing that it's a world of ghosts basically. They don't like there's no standing room, there's no bodies, there's no corporeal anything, and then that construct is totally useless to us. We can't use it for any conclusions. Like even the Robinson Crusoe example, Crusoe economics is a realistic example. It could happen. It's just it's rare. And the
Hmm.
Garden of Eden thing really couldn't happen. Or like the evenly rotating economy example of Mises
Yeah.
and Rothbard, that could never really happen. You just assume that to be the case to isolate some features of the world that you're trying to explore for understanding time preference or interest or something like that. But even that could never really happen because the future is uncertain, as Mises elsewhere demonstrates, is unavoidable. It's inherently uncertain because it hasn't happened yet, and our knowledge is not. We're not omniscient.
I had another question. I guess one of my biggest problems when trying to understand the argumentation ethics was how the conclusions that you can derive from it. For example, if it's the case that you cannot logically argue that for conflict, then it's a necessarily peaceful action. One of the common critiques I see is, oh, well, there are other norms that you presuppose in argumentation, so therefore you can't argue against those. One of those being that you have to be awake, so therefore it's unjustifiable to argue for sleeping, or same
Yeah.
for, yeah, something like I've heard that one before, and I didn't necessarily, it was during a debate, and I didn't necessarily see a good response to that. I want to know what
I
you
think
think about.
those are all variants of the you can't argue with your slave in a sense,
Yeah,
and I think they also miss the they miss the point that there's another argument they'll say like, well, all you've done is prove that during an argumentation we have to respect property rights,
just
but
during the course.
once the argument's over, then we're back to I don't know, a world of no norms. It's like,
Yeah,
yeah, but the whole purpose of the argument is the argument is not about the argument itself. It's about how we handle situations in the world when we're not arguing. It's about who's going to own, the land that they use. Who's going to own it? If the question is who's going to own it, then you're just answering this kind of hypothetical question about it's a general question. So the point is, if in the real world outside the argumentation, if you want to respect, if you want your actions to be justified, they can only be justified in accordance with the norms that you could justify in an argumentation. So if you don't care about your actions being justified, then you can just do it. So
yeah,
it is true that the norm, but that's almost like saying, okay, I'm arguing with someone who has a very short attention span, and I might persuade them right now that they shouldn't take my chocolate, but they're going to forget this, and in 10 minutes they're going to take my chocolate anyway. So why would I bother arguing? Like, why would someone bother engaging in an argument with someone if they're treating it like a game and they're going to just start misusing? Like, they're going to treat me like their slave as soon as the argument's over. I guess I'll never end the argument. Then I'll stay arguing with them forever,
yeah.
so they'll at least treat me with respect during the
I've
argument.
heard that one before too, that if you presuppose that you should be arguing, therefore argumentation
Yeah.
ethics say that you should never stop arguing.
Yeah, and the other thing to keep in mind is most people that are making these criticisms of argumentation ethics, it's because, well, some of them agree with libertarian ethics. They just don't like Hoppe's argument.
Yeah,
And I want to say to them, it's like, well, then, so Hoppe simply argues that you can't argumentatively justify socialism. If you're a libertarian, you must believe that too. You must think for some reason you can't, there's no good argument, there's no good justification for socialism. And that's all Hoppe's saying is there's no good argument for socialism. He's just pointing out why. It's because when you argue, you're adopting norms that are inconsistent with it. But because you're a libertarian, you already agree with those norms too. So it's not really clear why libertarians don't agree with it. But when you're arguing with someone else, if they're criticizing argumentation ethics or if they're criticizing libertarian ethics, and if one of their arguments is, well, your argument for rights is flawed because uh, it doesn't apply to people that are sleeping or something like that,
yeah,
it's like they usually have their own alternative argument. So their alternative argument is like, well, in my view, the better argument is that we should all live in an egalitarian society and we should have the right to welfare and all this stuff. Then you could just tell them, you could come back to them and you could say, well, doesn't your argument only apply to people that are not sleeping? Or like you made that argument when you're awake. Does that mean that someone sleeping can't make that argument? So therefore socialism is not a good system because no one can make the argument all the time. I mean, again, it's like the lifeboat thing. It's like libertarianism doesn't solve that problem, but socialism doesn't either. And if you point out that argumentation can only happen between rational, conscious people who are not sleeping, okay, well, I can aim that back at any kind of rational discussion about any norms. I don't see why it's especially picking on argumentation ethics to make that point.
the same kind of retort that I've seen in response to critics of your estoppel ethic, actually. People talking about how, oh, well, when they try to particularize it, like, oh, I'm me, and therefore I can do what I just did. Like, let's say it's kick you, and then you can't do it back to me because you're you. And then how they could just turn that back and be like, oh, well, I'm me, and so I can. Or even if it was like, oh, well, I used to think this, now I don't, I
Right.
regret it. And they're
Right.
like, okay, well, I'm going to hit you as punishment, and then I'll
Yeah.
later regret it, and then it'll be
Yeah.
fine,
Yeah.
according to your own ethic.
Yeah. My estoppel thing has not gotten quite as much attention as Hoppe's, and so it also hasn't gotten quite as much criticism. But on occasion, I'll get something like that. And my response was already buried in a few sentences in the original article I wrote about it. And it's simply that if you're if you committed aggression against me and then I try to retaliate and your response is you can't do that to me because I own my body and it's wrong to use my body without my permission, then once you grant that, you're granting that you have to acknowledge that you shouldn't have done what you did to me previously, and you do, because usually in the hypothetical they say, oh, I admit I shouldn't have done that. I
Yeah.
apologize. I shouldn't have done that, but now you shouldn't do it to me because we both agree that it's wrong to do that to people. It's like, yeah, but you not only agree that it's wrong to do that to people, you agree that you did it and that you shouldn't have done it. And if you agree that you shouldn't have done it and that you did it, and you agree that there should be a law against it or some kind of enforceable rule against it, then you have to agree that some response is justified. Because if no response is justified, and the response has to come after, so that's the thing, the response has to come after the fact, because nothing is simultaneous. So the response to an act of aggression has to come after the act of aggression. So if a response is going to be justified, it has to come after, which means that the fact that someone now agrees with you doesn't change that fact, or that it's irrelevant. And if you say, well, the fact that a response has to come after means that you can never have a response, then that means that we don't have any rights at all. That means that we're back to mere shoulds, or we're back to a might, race, track world, either one or the other. So again, once you concede that there should be rights and there are enforceable rights, and you concede that the response has to come after the fact, then once you admit that you committed the act, then you basically, I would say, you're stopped from from withholding your consent. That's why, in a sense, when you use force against someone who says the word no, in a sense, they've already consented. And again, this is why I would distinguish the voluntary slavery thing, or the kissing, or the having sex with a girl who said yes before. She can change her mind, and in her case, her later consent is the one that matters. And the reason is because she hasn't committed an act of aggression. If she had committed an act of aggression first, that would have stopped her from withholding her consent later. Okay? That's why a criminal is stopped from complaining about force being used against them after, because in a sense, they've already granted their consent in their act of aggression, and it's too late for them to change their mind. But if I merely make words to you and I say, I will kiss you at the end of the date, or I will be your slave, I haven't committed aggression, so I can change my mind. That's the distinction, which is really apparently hard for some people to see. To my mind, it's very simple. You got to keep it clear in your mind, the distinctions, but it's easy to see why there's a distinction. An act of aggression is a fact that happened and it cannot be undone. Saying something to you didn't harm you, so it can be undone. I can take it back. I can change my mind. That's the difference. And that's what Walter Block doesn't see, because he just keeps thinking, but I promised to be your slave. I can't undo it any more than I can undo the sale of the car. It's like, yeah, but they're not because of promises, they're not because of obligations. They're because of the way you come to own these things. So I think when you untangle all these things, have a clear view, then all these conundrums, you can see why people get confused about it, but you can see why they're just wrong.
One of my I don't want to get too deep into estoppel, but that's something I've always found a little confusing myself. I understand how you can't later retract that, oh, you shouldn't aggress on somebody, because I guess I wouldn't, I doubt you would call it aggression to use force against somebody who aggressed. You know, not
Well,
just
yeah,
in
so
self-defense, but
so there's two ways you could word it. So if I'm the recipient of aggression, when I use force against them, you can distinguish it. You could say it's response. I call it responsive force. It's force that's not in response. So when they initiated force against me, their force was not in response to any act of force I committed. So it's initiated or aggression. When I respond, it's responsive. So that's one distinction. And then the other way you could look at, you could say, well, it's not even by being responsive. It's another way of saying that it's consented to. it's consented to by the aggressor when I aggress against his body, because even though he's mouthing the words no, he's stopped from saying that because of his previous act. So
Yeah.
you can look at it either way. You could say that I can use force against him because it's responsive force and it's justified, or it's because he's consenting to it now because he can't withdraw his previous consent. Either
Okay.
way is a kind of an equivalent way of looking at it.
I used the estoppel method in a paper I wrote in my Greek and Roman drama class. We were going over the Orestean trilogy with Clytemnestra and Agamemnon, and Clytemnestra killed both Agamemnon and Agamemnon's concubine. And the question was whether she was justified in her actions, and I gave a defense for her actions of killing Agamemnon because Agamemnon killed her daughter,
Okay.
but not Cassandra, the concubine, because she was just a bystander in the
Hmm.
situation.
Hmm.
Uh, I think it was perceived pretty well, but I just as a way to see if I understand something,
Yeah.
I try to use it myself.
There's
That's
a there's
leads me
a
to yeah.
I don't know the classics as well as you do. By the way, did you ever heard of the St. John's School, the one in Maryland?
I am not.
Yeah, it's got a deep classics program there,
Okay.
and it's quite interesting. That's I think
School.
I would have wanted to go there if I was studying classics, something like that. Um, but there's an example in Roman law I use. There's a the most famous of the Roman the most famous of of the five famous Roman jurists was called Papinian, and I think it was around the year 200 AD. It was when Caracalla, you know, you see the movie
Yeah.
Gladiator?
The new one? No, but that's during the his
Yeah.
reign, yeah.
Well, in the new one, it's in the reign. It's a few years later, maybe a generation later, and it's in the reign of the not twins, but the sibling brothers, Caracalla and I forgot the other one's name. But anyway, Caracalla, and the other one, um,
Geta?
Yeah, Geta. And I think
Ge-
Caracalla had Geta murdered, and in the movie, Caracalla's killed like a day late, 5 days later. But in
mm,
reality, Caracalla lived another 8 years until another guy became emperor. But anyway, after he had his brother killed, he went to Papinian, who was the chief jurist at the time, and he asked him to compose a justification for what he'd done because it kind of didn't look bad that one emperor killed his co-emperor, his brother. So he wanted him to compose a justification saying, no, no, he had a right to kill him for the following reasons. And Papinian says, he said this quote, which I love, is it is easier to commit, it's easier to commit murder than to justify it. So he refused to compose a justification. And what he meant was, there's a difference between fact and norms. There's a difference between oughts, shoulds, and facts. And the fact is you murdered him. That's might. But the right was it was a crime, and there's no justification for it. And so um, Caracalla had Papinian tortured and executed because he refused to compose a justification. But he was right. He was right to refuse to because there is none.
Good. It's good. It goes perfectly in hand.
And I need to go in a few minutes. So if you got any final, and we can
Oh, no
talk later if you
worries.
need to,
But I greatly appreciate it. My last question actually I think would be a good way to wrap it up. It
okay.
was, what is the main thing that critics misunderstand about argumentation ethics? If you had a So probably restricting to try to pinpoint to one thing, but if you had to think,
Well, I think a lot of them don't. I mean, Hoppe is a very dense writer, and he also
yeah,
writes in this Germanic style. And his original books were all He wrote them, but then his wife and others had to help him clean up the English. So I think he says a few things in passing that you can just glance over and not really get the import of. Like he says like there's three or four things he says that are extremely important to his argument. One is that all argumentation is necessarily argumentative justification. Okay. You can't justify anything, especially anything normative, except in a justification. So if you can't do it in justification, you can't do it at all. I mean, if you can't do it in an argument, you can't do it at all. And if argument has certain normative presuppositions, then those are ones you can never argue against. Okay. So then the question is, what are those arguments? What are those? And then when he says that, and the right to agree to disagree is also extremely important. He just sneaks that in, but it's an extremely important thing because it shows the distinction between a real argument where you're trying to persuade someone by force of reason alone, the force of your words alone, which he says, um, and coercive threat, which is not a real argument. You're just trying to get someone to say, to agree with you, to say words so they don't get hit. Um, and then this thing about argument is a practical affair because in the real world, you have to have standing room and the right to control your body, but you also have to have the ability to control scarce resources right now and also to have gotten there in the first place, which means this right to, you have to presuppose the right to first start using something, right? And then the prior later distinction that ties back in this regression. So all four or five of those things kind of combine together. So I guess probably the biggest misconception of argumentation ethics is, well, I guess there's a couple. One is failure to understand all these things in an explicit way. And if you just reread it and listen to it enough, you get that part. Then the other is sort of this hostility towards what they think of a priori or transcendental reasoning or what they call knockdown arguments. They sort of want to be stuck in this Nozikian model of always having just kind of making it a game and never settling on anything, or even the idea, I think David Friedman and some others, they've said, or Nozick or someone like, it's almost oppressive to have a knockdown argument, to say that there are some things you just can't argue without running into a contradiction. They think that's oppressive to like, they think it's almost coercive. It's like, I don't think it's coercive.
Really?
And then I guess the slave and the like someone arguing with their slave, they think that's a counter. But a lot of people haven't read it deeply enough to know that. Or maybe some of them just don't. A lot of them are Randians too. A lot of Randians have a hostility towards Kant. That could be part of it. They have a
That makes,
hostility
yeah,
towards Kant because of Rand's hostility towards uh,
altruism.
what she calls subjectivism, which she really means, I think, moral relativism or skepticism. Um, I'm not a deep philosopher, but I've been persuaded by Hoppe and others that Kant was a murky writer in a way. So people that have a certain interpretation of him could be forgiven for it because he was murky. But my understanding is there's one tradition of interpretation of Kant's views, like on ethics and epistemology and stuff like that, in America, the American tradition, and one in Europe, the continental tradition. And the continental tradition is far more realistic, and that's what Mises and Hoppe come from. So they're not real. They're realists. They're not idealists, and they're not skeptics at all, especially not Hoppe. And then the American realists, the American Kantians sort of have this more idealistic, skeptical interpretation of Kant. And the argument is that Rand, when she didn't really read Kant in the original sources, she read secondary sources, and she was reading some Americans who were arguing for kind of a skepticism. So when she's attacking Kant, she's attacking this kind of skeptical
Yeah.
moral relativist version of Kant. In any case, I think the hostility of a lot of libertarians who are Randian influenced to Kant might be one reason they just are averse to Hoppe's seemingly Kantian a priori, all that stuff, inspired argumentation ethics, and their hostility towards Mises, who they think no, Hoppe's argumentation ethics is not really Misesian. I would say is grounded in I'd say Hoppe's argumentation ethics is grounded in Mises's basic praxeological Kantian
Yeah.
way of looking at things. It's also grounded in the political realism of Rothbard and radicalism of Rothbard. And it's also grounded in some of the insights of his professor Jürgen Habermas and Karl Otto Appel, which were both kind of Democrat socialist types, but kind of the argumentation ethics insights. So all that kind of combination of stuff is where Hoppe got it from. But even Mises was sort of a Kantian, and he was a utilitarian in ethics, not really principled, more consequentialist or pragmatic. And I think so. The Randians have this hostility towards Mises is what they would call subjectivism, which is not subjectivism. in the Randian sense. But anyway, so I think it could be because of their kind of knee-jerk hostility towards what they perceive as Kantianism.
Because
Um,
the way he goes about the norms of argumentation did remind me of Kant's categories when reading it.
yeah, and the Randians also, if you read Prisky Ibarra's book, I think it's called Total Freedom, where he goes into his philosophy. He's trying to defend Rand, but show that her method is heavily dialectical, right? She's trying, and she always does try to, if you read her stuff, she always tries to um, she tries to explode dichotomies. And I might not be using the right term,
Yeah.
but like like the mind body, the analytic synthetic dichotomy, the mind
Yeah.
body dichotomy, dualisms, things like that. And she did that a little bit even with knowledge. Like she doesn't like this a priori versus a posteriori way of looking at things. Um, Even though her own way of looking at knowledge is very similar to the subjectivism of the economics of Mises in terms of we demonstrate that we subjectively value things by our actions. He didn't mean that all ethics were were morally relative. It's a different use of subjective. Um, and uh, and so like so she would have so when she says there's axioms, for example, she meant axiomatic knowledge. So we know some things to be absolutely true because they're self-evident, and the attempt to deny it leads to self-contradiction. Like you can't deny that there's consciousness because and therefore you can't deny that there's existence because you gotta and you can't deny there's a difference a distinction between you and the outside world because to be conscious is to be conscious of something. It's a relational property, right? And you can't deny the law of non-contradiction because it's at the base of what it means to have a contradiction at all, or falsity and
Yeah.
truth. Like all these kind of elementary things that she builds her philosophy on, she calls them axiomatic, which is, I think, not the standard way philosophy uses the term axiomatic. What she meant was self-evidently true, so that denying it leads to self-contradiction. So it's something you could never show is wrong. And that's the same way that Mises argues with about the human action axiom and aspects of praxeology. And it's the same way Hoppe argues
With the norm.
about his norms. So it's all the same way of arguing about what's true and what's not true, what's obviously false, and all that stuff. So I think she just didn't want to use the word a priori because it's too sounds too Kantian to her, right? Um, anyway,
Awesome. Thank you very much for giving me this opportunity. This has been very helpful, and I still have to go through and organize, clean up all my notes, and then finish this paper in March. But this has been
yeah, if you
great.
write the paper, if you want any feedback, I'll be happy to do it. And if you
Oh,
end up publishing it,
thank
that'd
you.
be great. Send me if it's published, and if you don't, if you want to publish it like in the Journal of Libertarian Studies or something like that, you could think about that if it's not suitable for yours. So we can talk about that
Oh,
later.
wow. Okay. Thank you. Thank you.
All right. Well, good luck with
Uh,
everything, and I'll send you the recording when this is
okay.
done.
Great. Thank you. Have a good night. Take care.
All right. Take care.
Ciao.